ফার্স্ট অফ অল ভায়োলিন সবাইকে আজকে আমাদের এক দুঃখের দিন। আমাদের বলতে কাদের? যারা আমরা নতুন করে ল পড়াশোনা শুরু করছি, অর্থাৎ আজকে থেকে যারা নতুন করে এই উচ্চ মাধ্যমিক দিয়ে ল পড়তে ঢুকবে, বা যারা এখনো ল পড়ছে, ফার্স্ট ইয়ার, সেকেন্ড ইয়ার, থার্ড ইয়ারে পড়ছে, বা যারা লাস্ট ইয়ারে পড়ছে, বেরোবে, 5 ইয়ার এলএলবি করছে, তারা যারা চেয়েছিল যে আমরা ওকালতি করবো না, ডাইরেক্ট জাজ হব, জজের জন্য রেডি করছিল, তাদের জন্য আজকে একটা বিরাট সেটব্যাক, একটা বিরাট নেগেটিভ রায় হয়েছে সুপ্রিম কোর্টের তরফ থেকে। প্রথমেই বলি যে আমরা মহামান্য সুপ্রিম কোর্ট এবং আমাদের মহামান্য সুপ্রিম কোর্টকে পূর্ণ আস্থা, ভরসা, বিশ্বাস, পূর্ণ মর্যাদা রেখেই কিছু প্রশ্ন করব, এবং এই প্রশ্নটা আগামী দিনে তোমাদেরও সবাইকে বাই মেল হোক, বাই পোস্ট হোক, সুপ্রিম কোর্টের সিজিআই এর কাছেও পাঠাতে হবে, সলিসিটর জেনারেলের কাছেও পাঠাতে হবে, ইভেন ল মিনিস্টারের কাছেও পাঠাতে হবে, প্রাইম মিনিস্টারের কাছেও পাঠাতে হবে, এবং আমাদের রাষ্ট্রপতি, উপরাষ্ট্রপতির কাছেও পাঠাতে হবে। আমরা কোথা থেকে সাহস পাই? না, আমরা সাহস পাই সুপ্রিম কোর্টের উপর আমাদের আস্থা, ভরসা, বিশ্বাস আছে বলেই। আমাদের সুপ্রিম কোর্টের উপর পূর্ণ আস্থা, বিশ্বাস আছে এবং আমরা পূর্ণ মর্যাদা রাখি, এবং আমাদের সুপ্রিম কোর্ট ছাড়া কেউ সুপ্রিম নেই, এবং কনস্টিটিউশন ছাড়া আমাদের কেউ সুপ্রিম নেই। যেরকম ভাবে বর্তমান প্রধান বিচারপতি আর গওয়াই বলেছে যে ভারতবর্ষের সুপ্রিম হচ্ছে কনস্টিটিউশন, এবং সেই কনস্টিটিউশনকেই আমরা লালিত পালিত করব, জুডিশিয়ারি, এক্সিকিউটিভ এবং লেজিসলেটিভ। ঠিক আছে, তাহলে আমরা সেইখান থেকে সাহস পাই সুপ্রিম কোর্টকে প্রশ্ন করার। যেভাবে মাননীয় উপরাষ্ট্রপতি প্রশ্ন করেছেন, মিসাইল, অ্যাটম বোম, কত কিছুই না বলেছেন উপরাষ্ট্রপতি, এবং রাষ্ট্রপতিও, মাননীয় রাষ্ট্রপতিও কিন্তু চিঠি করেছে সুপ্রিম কোর্টকে, জানাতে চেয়েছে সুপ্রিম কোর্টের কাছে, তারও জানার ছিল বলে তো সুপ্রিম কোর্টকে আমাদের মাননীয় রাষ্ট্রপতিও চিঠি লিখেছে যে সুপ্রিম কোর্ট কি রাষ্ট্রপতিকে নির্দেশ দিতে পারে কত দিনের মধ্যে বিল সই করতে হবে, না করতে হবে, এগুলো নিয়ে। এবং অতি সম্প্রতি আমাদের মাননীয় উপরাষ্ট্রপতিও বলেছে যে এটার কোনো সাংবিধানিক ভিত্তি নেই, যে কমিটি করা হয়েছে, যে ওই জাজের বাড়িতে যে টাকা পাওয়ার ব্যাপার নিয়ে, অপরা টাকা পাওয়ার ব্যাপার নিয়ে যে একটা কমিটি গঠন করা হয়েছে, তিনি সেটাকেও অসাংবিধানিক এবং ভিত্তিহীন বলতে সাহস করেছেন। তো মাননীয় উপরাষ্ট্রপতি যদি সুপ্রিম কোর্টকে মিসাইল, অ্যাটম বোম বলতে পারেন, বা রাষ্ট্রপতি, মাননীয় রাষ্ট্রপতিও যদি সুপ্রিম কোর্টকে প্রশ্ন করতে পারে, আমরাও সিটিজেন অফ ইন্ডিয়া হয়ে, আমরাও একজন সাধারণ দেশের নাগরিক হয়ে সুপ্রিম কোর্টের কাছে কয়েকটা প্রশ্ন করতে পারি। এবং এই প্রশ্নগুলো আজকে যেটা তোমাদের করবো, সেটা আমি কোনো ওই মানে একটা আকাশ থেকে পড়বে না, সবকিছু যুক্তির আলোকে করব এবং তথ্যের ভিত্তিতে করব। তোমরা সেগুলো নোট ডাউন করবে, এবং নোট ডাউন করে তোমরা প্রত্যেকে চিঠি ড্রাফট করবে। প্রত্যেকে যারা অ্যাসপিরেন্টস ইন ফিউচার জাজ হওয়ার জন্য, তারা প্রত্যেকে পাঠিয়ে দেবে। আমি যা যা বললাম, সিজিআই কে পাঠাবে, সলিসিটর জেনারেল কে পাঠাবে, ল মিনিস্টারকে পাঠাবে, প্রাইম মিনিস্টারকে পাঠাবে, রাষ্ট্রপতিকে পাঠাবে, উপরাষ্ট্রপতিকে পাঠাবে। এবারে প্রথমে আমাদের কি হলো আজকে জাজমেন্ট, যে আমরা সেটাও একটা বার অ্যান্ড বেঞ্চ প্ল্যাটফর্ম আছে, আমরা জানি। তো আমরা এখন সরাসরি কিছু ডকুমেন্টে চলে যাব, লাইন বাই লাইন আমরা স্ক্রুটিনি করব। আমি কিছু বক্তব্য রাখবো না, বক্তব্য যা দেওয়া আছে প্রিন্টেড, আমি সেগুলোর শুধু প্রশ্ন জানতে চাইবো মাননীয় সুপ্রিম কোর্টের কাছে, পূর্ণ আস্থা, ভরসা, বিশ্বাস রেখে, যে এই রায় কিসের স্বার্থে, কি এ থেকে সমাজ বা দেশ পাবে। ঠিক আছে, তাহলে তোমরাও প্রত্যেকে, স্ক্রিন আমি শেয়ার করছি, তোমরাও প্রত্যেকে দেখতে পাবে। ফার্স্টলি আমি যদি যাই, উইন্ডো ওপেন করছি, এই উইন্ডোটাতে যদি আমি নেই, শেয়ার করলাম, তোমাদের সামনে একটা সুন্দর করে জিনিস এসছে, তোমরা দেখতে পাচ্ছ। এখানে আমরা প্রথমে আজকের জাজমেন্ট দিয়ে যে নিউজ বেরিয়েছে সেটাতে আগে আমরা প্রথমে আলোকপাত করি। সেখানে কি বলা হচ্ছে আমরা দেখি না। In a significant judgment, the Supreme Court on Tuesday ruled that a candidate should have at least 3 years of practice as a lawyer to enter judicial service.
Hello, sir.
The judge were there who had the judge that the judgment was pronounced by a bench of Chief Justice of India, Honorable Chief Justice of India, CTI B.R. Gavai, and Justice A.G. Nashe and K. Vinod Chandran. Okay. কোর্ট এখনো আমরা জাজমেন্টের কপি পাইনি, এখনো জাজমেন্টের কপি সুপ্রিম কোর্টের ওয়েবসাইটে আপলোডেড হয়নি। আমরা সেটাও দেখব এবং সেটা নিয়ে আরো আগামী দিনে আলোচনা করব এবং আমরা চাইবো যে এই রায় বদল হোক এবং এই রায় আবার রিভিউ করা হোক বা এই রায়টাকে বদলানো হোক। বলা হচ্ছে উই হোল্ড দ্যাট দ্য 3 year।
হ্যালো স্যার।
বলো।
হ্যালো। হ্যাঁ স্যার, বলছি আপনার যেটা প্রেজেন্ট করছেন সেটা স্ক্রিনে শো হচ্ছে না।
আমি যেটা স্ক্রিন শেয়ার করেছি সেটা তোমাদের কাছে শো হচ্ছে না?
না স্যার, আমি তো দেখতে পাচ্ছি না।
সবার কাছে হচ্ছে, ভালো করে দেখো।
স্যার আমি তো করেই যাচ্ছি।
আমি শেয়ার করেছি, বাকি স্টুডেন্টদের কাছে শেয়ার হচ্ছে। তুমি একবার দরকার হলে আর একবার আউট হয়ে দেখো, তোমারটাকে দরকার হলে আমি প্রেজেন্টেশনটাকে দেখতে পাচ্ছ?
না স্যার, কিছু দেখতে পাচ্ছি, শুধু ওই লোগোটা দেখতে পাচ্ছি, মানে সরকারি সম্পর্কের ওই লোগোটা, আর কিছু দেখা যাচ্ছে না।
ঠিক আছে, তুমি তাহলে শুনতে থাকো। হ্যাঁ
স্যার, বলছি গ্রুপ থেকে বেরিয়ে আবার জয়েন করলে দেখা যাবে?
হ্যাঁ করো।
ঠিক আছে।
We hold that 3 year minimum practice requirement to appear for civil judges junior division exam is restored. The শব্দ restored. Why it is restored? কারণ এটা আগে ছিল 1993 থেকে, এটা ছিল 2002-এ, এটাকে আমরা চেঞ্জ করেছি। ঠিক আছে, এবারে সেটাতেও আমরা আসবো। রিস্টোর কেন হলো? এটা নতুন কিছু হলো না, এটা আগে ছিল 2002 থেকে, তারপরে আবার এটা পুনরায় করা হলো। ঠিক আছে। All state governments shall amend rules to ensure that for any candidate appearing for civil judges junior division exam shall have a minimum practice of 3 years. This shall be certified and endorsed by a lawyer having standing of 10 years at the bar, experience as a law clerk to judge shall also be counted in this regard. Their judicial service entrants must undergo a year of training before presiding in a court, the court ordered. The court, however, clarified that these requirements will not apply to ongoing judicial recruitment. It's an important জায়গা, but will apply prospectively in the future. Minimum practice requirement shall not be applicable where the high courts have already commenced the appointment process of civil judges junior division, and this shall be applicable only when the next appointment process begins. The court said, okay. The court reasoned, very important as per the news, the court reasoned that the appointment of a fresh law graduates as judges has led to a lot of problems. Okay, underline. Inexperience, underline. Law graduates may not be adequately equipped to handle the important task entrusted to judicial officers, the court opined. Wow. Judges, from the very day they assume service, deal with the matters of life, liberty, property, etc. It cannot be answered only by knowledge of books, but by assisting seniors during legal practice. Understanding court, thus, we agree that the reintroductions of some service as a lawyer before the judicial exam is needed. Got it? Any problem? It clarified that the 3 years of legal practice can be counted from the date on which a law graduate starts practice on the basis of a provisional enrollment, and not from the date on which a lawyer clears all India Bar Exam (AIBE). We hold that experience shall be counted from when provisional registration happens. This is because AIBE is held at different times. The court said, whether or not a candidate has 3 years of legal practice is to be certified by an advocate with 10 years of standing at the bar. The court further said it also held the candidate experience as a law clerk to a judge can be counted towards legal practice. All such recruitment process which were kept in abeyance due to the pendency of this case shall proceed now in accordance with the amendment rules as notified, the court added. A copy of the detailed judgment is awaited, as I told you earlier. The case arose from a series of petitions challenging a mandatory 3-year legal practice requirement for aspiring civil judges, introduced by the Madhya Pradesh High Court through our 2002 amendment to its judicial service rules. As I told you, what was in 2002 we will look after also further in process. These rules subsequently adopted by various other states required candidates to have at least 3 years of experience as a practicing lawyer before they could appear for judicial service examinations for entry-level civil judge junior division positions. The rule was introduced with the intention of ensuring that those appointed to the judiciary had a foundational understanding of courtroom procedures and practical legal skills. Then, including the Bar Councils of India and the several state bar councils, argued that the prior practice at the bar equipped judges with the necessary experience to handle complex legal issues effectively, thereby enhancing the quality of judgments and maintaining the credibility of the judiciary. However, the rule faced significant opposition. Now, note down, however, the rule faced significant opposition from law graduates and academicians who argued that it imposed an arbitrary barrier to judicial service, effectively restricting equal opportunity for fresh law graduates. They contended that the requirement went beyond the constitutional mandate and disproportionately limited access to the judiciary, deterring young meritorious candidates from pursuing judicial careers. The legal debate primarily centered on the interpretations of the Article 233 subsection 2. The Constitution Article 233 subsection 2. Constitution's Article 233 subsection 2 of the Constitution, which specifies that the person not already in the service of the Union or the state can be appointed as a district judge only if they have the practiced as an advocate or pleader for not less than 7 years. However, these provisions apply specifically to district judges and not necessarily to junior division civil judges whose eligibility is typically governed by the state and the service rule. In the 2002 All India Judges Association versus Union of India case, the Supreme Court had observed the need for practical experience for judges but did not make it a binding requirement. Since then, judicial service rules varied widely across states, some enforcing the 3 years minimum practice rule, while others continue to permit direct recruitment from law school. Okay. Now, here we are, আমরা আলোচনা করলাম তিনটে জিনিস নিয়ে। কি? একটা হচ্ছে 233-2 কনস্টিটিউশন কি বলছে যে কাউকে জাজ হতে গেলে তাকে মিনিমাম 7 বছরের প্র্যাকটিস করতে হবে। যদি তাহলে আজকে আমরা কনস্টিটিউশনকে সম্মান করি বা কনস্টিটিউশন ওয়াইজ চলি, অ্যাজ আওয়ার অনারেবল চিফ জাস্টিস অফ ইন্ডিয়া সেজ কি সুপ্রিম কোর্ট বা পুরো জুডিশিয়ারি, লেজিসলেটিভ এন্ড এক্সিকিউটিভে আমাদের বেস বা প্রাইমারিলি মেন সুপ্রিম কে কনস্টিটিউশন অফ ইন্ডিয়া বলেছে। তাহলে 7 বছর করে দাও। প্রথম প্রশ্ন সুপ্রিম কোর্ট। হ্যাঁ, আমি বলছি সেটাও কি 7 বছর করেছো? তাহলে তুমি কনস্টিটিউশন কি অ্যাবাইড করছো না? তুমি কি অ্যাবাইড করছো? তাহলে কনস্টিটিউশন যখন তোমাকে বলছে যে মিনিমাম তোমাকে 7 বছরের জন্য করতে হবে সুপ্রিম কোর্ট বলতে, তাহলে সুপ্রিম কোর্ট বলে কনস্টিটিউশন অফ ইন্ডিয়া এতদিন বললো, এবং তারপরে 2002 থেকে আমরা আজ পর্যন্ত না 7 বছর কোথায় ধরেছি আমরা? না 7 বছর ধরলাম, না 3 বছরও ধরলাম, না 1 বছরও ধরলাম। ডাইরেক্ট লস মিলস থেকে তো আমরা এতদিন দিচ্ছিলাম। কেন দিচ্ছিলাম? আমরা তাহলে চলে যাবো 2002 কি ঘটেছিল, কি অবজারভেশন ছিল সেটা জানতে কেস লতে চলে যাই। আমরা আগে যাই, তারপর আমরা সুপ্রিম কোর্টকে, অনারেবল সুপ্রিম কোর্টকে কিছু প্রশ্ন করব, যেটা তোমাদের বারবার আমি বলছি তোমাদেরও দায় একটা আছে, সেটা হচ্ছে সিজিআই কে, প্রেসিডেন্ট অফ ইন্ডিয়া কে, ভাইস প্রেসিডেন্ট কে, প্রাইম মিনিস্টার কে, সলিসিটর জেনারেল কে, ল মিনিস্টার কে লেটার রাইট করা, মানে লেটার ফরওয়ার্ড করা, এবং বাকি যা লয়ের ব্যাকগ্রাউন্ডে কাজ আছে প্রেপ করা বা যাওয়া বা আবার রিভিউ করানো সেটা আলাদা। কিন্তু আমি জানতে চাই এই সুপ্রিম কোর্ট যে এই ভার্ডিক্টটা দিলেন নিশ্চয়ই সবকিছু নির্বাচিত মানে ভেবে চিন্তেই দিয়েছে। তাহলে এই প্রশ্নগুলোর উত্তর কি? সেটার প্রশ্নের উত্তর হচ্ছে অল ইন্ডিয়া জাজেস অ্যাসোসিয়েশন এন্ড আদার ভার্সেস ইউনিয়ন অফ ইন্ডিয়া এন্ড আদার্স 21 মার্চ 2002। ঠিক আছে, কি লেখা হচ্ছে সেখানে জাজমেন্টে আমরা দেখি। In the All India Judges case 1993-4 to 88 page, at page number 314, আমরা ওইটাতেও যাব, ওই মানে 1993 এর অল ইন্ডিয়া জাজেস কেসেতেও আমরা যাব। আগে আমরা এই যে 2002 এর মামলার রেফারেন্স দেওয়া হচ্ছিল, অল ইন্ডিয়া জাজেস অ্যাসোসিয়েশন এন্ড আদার্স ভার্সেস ইউনিয়ন অফ ইন্ডিয়া, সেখানে কি অবজারভেশন আমরা একবার দেখি। তাহলে সেখানে কি ছিল না, দিস কোর্ট হ্যাজ অবজার্ভড that in order to enter the judicial service, an applicant must be an advocate of at least 3 years standing. Rules were amended accordingly. With the passage of time, experience has shown that the best talent which is available is not attracted to the judicial services. That time was in consideration. Is this not right now in consideration? That time, if some judgment was made under considerations of that, which point? That experience, they have experience. And now, this time, CGI and the others, honorable judge, is experiencing another thing. After the down length 20 years, okay? What that time they have experienced? That with the passage of time, experience has shown that the best talent which is available is not attracted to the judicial service. That means judicial service is suffering from the talented, best talent. A bright young law graduate after 3 years of practice finds the judicial service not attractive enough. I'm not saying my words, the words of the courts. 2002. After practicing 3 years, if he is settled in a practicing field, he might not be interested for the judicial, best talented. So we must encourage the best talent in the judicial service or not? We should. Okay. Then a bright young law graduate after 3 years of practice finds the judicial service not attractive enough. It has been recommended by the Sethi Commission. Okay, what Sethi Commissions? After taking into considerations the views expressed before it by various authorities, that time various authorities, and this time various authorities are different, that the need for an applicant to have been an advocate for at least 3 years should be done away with. After taking all the circumstances into consideration, we accept this recommendation of the SETI Commission and the argument of the learned amicus curiae that it should be no longer mandatory for an applicant desirous of entering the judicial service to be an advocate of at least 3 years. Standing, we accordingly, in the light of experience gained after the judgment in all India judges' cases, direct to the high courts and to the state governments to amend their rules so as to be enable a fresh law graduate who may not even have put in the even 3 years of practice to be eligible to compete and enter the judicial service. Clear? 2002 এর রায়, All India Judges versus Union of India, and it even ended in Supreme Court also. It is also in Supreme Court. That time 2002, 2025 20 বছর। আর কি বলছে? Advocate at least, advocate of at least 3 years standing accordingly in the light. Their rules should be enabled, not even put in 3 years to be eligible to complete the entire judicial service. We, however, recommend that a fresh recruit into the judicial service should be imparted with training of not less than 1 year. But that is the reason every state government had formed the judicial institute, and they are giving the 1 year training. Good enough? Okay. Preferably 2 years. 2 বছরও করতে পারো। The SETI Commission has recommended assured career progressive schemes and the functional skills. We have accepted the said recommendation, and a suggestion was mooted to the effect that in order that a judicial officer doesn't feel that he is stagnated, there should be a change in the nomenclature with the change of the pay scale, and the other views are coming to follow. Now we are going to again to the 1993. What is it is? All India Judges and the versus Union of India, another 24th August 1993 Supreme Court. Okay? 7 years. Constitution of India 232 by section 2 not followed. 1993 come, then 2002, now 2025. So all are vice versa. All are each other. Now it has, however, become imperative. What they are saying it's a very important manner. Now I am going line by line. It has, however, become imperative in this connection to take notice of fact that the qualification prescribed and the procedure adopted for the recruitment of the judges at the lowest rank, okay, that means lower, are no uniforms in all the states. Still, it is not all India Judicial Service is not. In view of the uniformity and the hierarchy and the designated as well as service conditions, and we have suggested it is necessary that all the states should prescribe uniform qualification and adopt uniform procedure in the recruiting the judicial officers. At the lowest rung in the hierarchy, in the most, it is the minimum qualification for being eligible to the post of the civil judge come magistrate, first class magistrate in the minimum 3 years practice as a lawyer. In addition to the degree in the law, in some states, however, the requirement of the practice is allowed to be altogether dispensed with the judicial officer, which is in 2025 is repetitive. Considering the fact that from the first day of his assuming office, the judges has to decide among others question of life, liberty, whatever. Right now is also saying the same thing: life, liberty, property, and the reputations of the litigations. Undergraduates face from the universities to occupy since the vital powers is neither prudent nor desirable. Okay, and here also in 2025, as also said, the use detrimental. Detrimental means which is hanikaro. That means which makes you affected. Okay. And again, universities to occupy seats such as power, prudent, desirable, knowledge, nor pre-service training can be adequate subsequent first-hand experience of the working of the courtroom system, the administration justice gotten through the legal practice The practice involves much more than mere advocacy. A lawyer has to interact with the several components of the administrative judges. Unless the judicial officers familiar with the same components, his education and equipment as a judges is likely to remain incomplete. Right now, whatever the judgment we are getting, it is quite the reflections of the 1993, isn't totally 1993 reflecting in 2025, and 1993 was criticized by 2002. So 1993 and 2025 it is similar, but the 1993 if it is challenged and observed, whatever the drawbacks of the 1993, so it should be applied to the 2025, isn't? So now with the confidence and many states have hence prescribed a minimum of 3 years practice as a lawyer as an essential qualification for appointment as a judicial officer at the lowest rank. It hence necessary that all the states prescribed in that the way. Here is the everything or whatever in that judgment I have given in the form. Now my question is to the Honorable Supreme Court, and your question may be, first of all, you are not relying on the universities and the colleges. Their way of teaching, their qualities. Then what need this degree, LLB? Ask to someone come to the advocate and learn the law and practice in the court. So he simultaneously know the everything. Why they go to the colleges? But here they are referring the law clerk and the law graduates in the same paragraph. They are saying if you are working as a law clerk, we also accept you. But your advocacy is there. They have to learn the court practice and the things. But as if you work as a law clerk, we will also accept. If you work as a law clerk, we will accept you. So what the difference, as you say? Why you are not asking them to go to any advocate to practice over there 5 years as a law clerk? So where is the relevance of the degree from the university? You are humiliate the degree of the university. You don't have the trust on the degree. This is my first question to the Honorable Supreme Court. That do you not believe the education system of India? Do you not believe enough that is the BA, LLB, UGC and the Bar Council approved, BCI approved? See, Bar Council of India approved colleges. That means that every surveillance and the supervision is done under by the BCI. So BCI offering colleges to give the degree and to prepare the students that they come to the field of the judiciary. So where is the relevance of this thing? When the constitution was framed into 33 by section 2, that was just the independence. That time just the independence we received. That type of infrastructure, education system, that much of law colleges, that much of law, judiciary and all these things was not properly made and prepared. So that time that was given, that the 7 years, because they, at the time of 1949 and 1951, at the time of the constitution's mid-up, that time there are lot of so-called law colleges, universities and nothing. So that time this doubt can be. But after the independence of the 70 years gone back, we are having same disbelief and mistrust on the universities and the education system of India. My question is, if I be a MBBS doctor after passing from the medical college, can I appear for the government doctor post or not? I can. Once I MBBS, I can surgery, or if I MS, MDS, whatever my degree pursue or what the degree I achieve, then after I can do that work or not. Doctor, I can make the operation. It's also life threat. If you say after passing MBBS, you practice with 10 years or 3 years with a surgeon or with another senior doctor, then you prescribe. Otherwise, the threat to life or not? It is threat to life or not? After getting my MBBS degree, once I prescribe the prescription of medicine, this is also a threat to life or not? Threat to life? So why I am not being asked to be practiced practically? Because book is not enough. As it is in the judgment is there that the book is not enough. Bookish knowledge is not enough. If it is so, book knowledge is not enough for the Supreme Court things. So why they not think about MBBS degree? Auto engineering, marvelous bridge is making. So that can be also collapsed if I don't have the practical knowledge. So after passing civil engineering, electrical engineering or any engineering new course, should I go for the practical knowledge and make a 3 years apprenticeship or gather the knowledge from the seniors or not? Should I? The same logic is there, and they are saying that is the life, liberty, reputation, and these all the litigations in the crucial area. So MBBS doctor having the direct threat to life. As you said here, why new lawyer cannot be joined judicial just because you were apprehended that could be detrimental, that could be affecting your judgment, that could be affect your this liberty and life and all these things, whatever they are mentioned here. What are the terms is like that? What are the terms? Yeah, that's a question of life, liberty, property, and the reputations of the litigants. Okay. So one MBBS doctor, after passing, he may write a prescription or not. If he gives the wrong prescription, then it's a direct threat to my life or not. So if after passing MBBS, you can write a prescription and you can give the drugs and we can assume and consume and we can go to fatal, we can be face death, is it? So it is direct threat to my life or not? It is threat to my life directly. So why you are not asking to practicing bookish knowledge is not enough? Why you are not asking to the engineers, even IAS and IPS? After graduating, they are taking the decisions of the districts. If they take the wrong decision, then who will be the sufferer? Then the public will be sufferer. You are not asking about the practice with the seniors. Okay, leave it the matter. If I am taking it as any profession, if you doesn't have the faith on the books and the knowledge, then you don't. You should stop this education system. You asked to be a law clerk, and as you said, law clerk can also be. If you work as a law clerk, you can also be a judicial aspirant. If you are working as a law clerk, you can also be a judicial aspirant. It's your verdict, your judgment. So if you are a law clerk and you can be a judicial aspirant, you will gather a lot of knowledge. But the book knowledge, university degree doesn't mean to. If the top 3 law university students, they have also goes to these advocates, might be they are not enough knowledgeable. This is not might be, this is the reality I am saying. Those advocates under leadership he will practice, might be they doesn't know anything. If I am talking about the top 3 law colleges or the law university students are passing out with the first class and top gold medalist, he will also go to practice. Then why you introduce in your course by the BCI moot court? What is moot court? You are saying there is no practical knowledge. So you ask the BCI to frame the course like that they will gather the practical knowledge. Why you not framing and changing and design the course of the LLB that whatever the inadequate or you think that is the shortage should be filled during the college days, is it? So if there is a moot court, you can frame the moot court in a way that they will be they can gather the practical knowledge as you wish, as you want. So for this, why you are asking to go for the 3 years practice? First of all, do you not have the faith on the books? Do you have not any faith on the universities? Do you have not any faith on the colleges and the universities and the education systems? And if it is not, why you are not directed to the BCI that please change the framework of the or design the course and you put the moot court 2 years. Make them in a 5 years or 3 years in LLB, or 5 years you make the LLB compulsory. But after passing, asking to practice, how it is relevant? You can make the law course to be 5 years, or you can say it would be 4 years, or if it is 3 years, in that course you should be moot court, practical, whatever the inadequacy, shortage you feel, you have to put it down over there. But you can't say that I don't feel that the book's knowledge is adequate enough. You need to go for the practice. So you ask to the MBBS doctor who should go for the practice, isn't? He also threat to our life, but you are not saying. You are saying to the advocates. Why? So why should I go to the college? Why should I earn the degree 5 years, 3 years? And if I doesn't wish to, then means my liberty be upheld. If I don't want to go to the court practice, is there mandatory? Why should I? I shouldn't be. A doctor must be go for the practice and to see the patient. He might be go to the directly professorship, lectureship, assistant professor. A doctor after doing MBBS, MD, BDS, he might be go to directly professorship, lecture, assistant professor. So why you are making this compulsion? No, you should go for the first practice. And you are not doing for the MBBS. You are doing for the advocate. Directly I can go judge. Because I earned the degree. And if you follow the constitution, then you follow the 7 years. Everywhere, whatever the written, it is also written in the 217 and 142 and 233 by 2, whatever the constitution, do everything. This is my first question. And the second question is to the Honorable Supreme Court. Do you know the practicality of the court? Any advocate can give us the place or space to learn the things, or they will make us appear, as you said, Lochner. And there is the chances of the high corruption. I appeal to Supreme Court to review this. Why? That the reason is any advocate by means of or by the against the money, by the means of the money, they can sign a certificate. Is there any guarantee that they have practiced 3 years or not? How can you judge? How can you follow? How can you restrict?
They say that you have to bring your 2 years.
No, that's right. So if you are my senior and I put you 10,000 or 20,000, will you give me the certificate or not? This is the harsh reality of India. You can't close your eyes and away from the reality. If you are my senior advocate, a lot of senior advocate is there, those practice is not well, but they are practicing for the last 10 years. If the law grads are going and they are paying the money without coming to the court also. After passing, so you are kill my 3 years. Practically, you are killing this year's my 3 years. Whereas this verdict is not relevant. Why it is not so relevant? Because any advocate can sign, oh, you have passed in 2025 and this is 2028. 3 years you are practicing. Can I sign a certificate or not? without coming or without visiting any day of the courtroom. Money power is there or not. So, senior advocate can also see, oh, you are not appearing in the court, so for this 10,000, and those are appearing for the court, they have to pay 5,000. Or might be 50,000 or the 20,000. Those are not coming to the court, need not to come to the court. After passing 3 years, you come to me, I will sign you a 3 years certificate. It can be possible or not. So, the corruption is there hugely. And then after I will go to the judge office. The judge officer should be abide with whatever the advocate has written to me. Because he will not challenge. As it is the doctor said, I am sick. Sick certificate. The reality in India, sick certificate once doctor written, he is sick. He admitted to the PG. He is entitled to be sick. Either the ESI and all these other places is suffering. This is the reality. That the doctor, by the means of their prescribing, he is ill or sick, so leave vacation in the factory or in the company. If the doctor is in favor of you and without having you have a fever, I can see you are a fever. You do not have anything, but I said this you have. I went hypertension and sugar and this. So you are sick, you need a leave for the 30 days with pay. One doctor certificate, if I pay to the labor officer should disburse my salary or not? Disburse my salary and I will be entitled as a sick. So if some advocate gives a false certificate, is your purpose to be served? Is your purpose to be served? Without knowing any practical knowledge, I can arrange any certificate from any 10 years practicing lawyer, advocate by paying the money. So why you are killing my 3 years? Where is the justification that I will get this certificate authentically? I can't say like that way. I know whatever you are saying. This is also family hierarchy. This is a family hierarchy because if I am from you want to eliminate the talented. You want to keep those having a board school fida. 5 years, 3, 7 years, no, they will come to in your legacy. So it will be dynasty. It will follow the legacy and dynasty. That son. Because other will not can keep their patience for this long 3 years. If a girl child or a woman passed into 23 at the age of 23 or 24, in what age they will marry and at what age they will be judged. So there is a career now. So 23 they will practicing for the judge, 24, 25 they will get the judge and then after they will marry. Once after marry, they are not being very concentrated at their father-in-laws in good enough for the study. So after passing my law, if a woman doesn't want to go to the court and he wants to join the judiciary, you are stop them. And can they keep their patience for 3 years? They will unmarried and they will keep that. After that, I will start my judiciary. And in between, eliminations. This is the play battle of the eliminations talent. So maximum number of talent will eliminate. Why? Because a lot of girls, those are aspiring for the judge. They are not keeping their patience after passing. Oh no. So might be the rush in the judiciary, as Honorable ex-CGI Chandrachud told to the BBC, that the regime can be patriarchal. It's a male-dominated regime. Once the girls must enroll in the system, so in the future we will get more and more lady judge. And the whole scenario of the judiciary will change. It It has already told by ex-CGI Chandrachud in BBC. Is it? You all have listened? So that means if a girl pass out after LLB pursuing for the judiciary and they are appearing for the judiciary and they get the judgeship, then after they can marry. But after passing 3 years, keeping the patience for the judiciary, it's quite impossible in the Indian tradition. Because within 23 to 27, they will be married. Isn't fertility, another biological, every aspect is there. So, after marrying, not marrying will come for this. And for those male, suffering middle class, lower middle class, after passing law, what they will do, they will keep crossing the 3 years that I will become a judge. They will start to earn money from somewhere. Once they settled in their orientations, practicing or job or a business or anywhere, if they settled in a 3 years, they will be unemployed for 3 years. They will be unemployed for 3 years, no, nah. They will never be unemployed 3 years. In these 3 years, once they will be, seasoned up, not as per for the judiciary. So the legacy and the dynasty to be followed, and the female to be eliminated, and those of the middle class family cannot come to this hierarchy as you say. That is the dogma. This is for ours. Nobody to be allowed. Why? Because this is for my son. Because this is for my grandchildren. Because I can feed off them for the 5 years. If I am a very rich man, my son no need to go for the 3 years any job or any, I can put up enough. And then after 3 years, he can go. But any middle class should earn the money, should struggle the life, should battle the field. So they will hurt and they will disappointed. And as it is in 1993, what they have told us? They have told us, right? In 1993 judgment, they have told us that we will miss the super talent. 1993 judgment. Sorry, 2002 judgment. Sorry, 2002 judgment. That is already said now. If we are not allowing them after passing the LLB, then we will miss the super talent. If he or she come from a middle class family, if he enjoy this opportunity, he can survive without practicing. But doing practicing 3 years, 6 years, and the scenario of the court, how much you can earn by practicing? If a boy, if a man passed in 22, 23, 3, 6, 26, how much he can earn by the practicing? So responsibility, liabilities of the family comes to him. So then he will earn more money. Say either join jobs or either go anywhere or any other places or do any other things, that they will not feel encouraged to join the judiciary because they have settled their life in their own terms, own points. So they are balancing. So they will aspire, because after graduation everybody will aspire for every big dream now. Who spoiled these big 3 years? Any doctor spoiled these 3 years? You are asking any civil engineer, computer engineer, after passing 3 years, you come to me for the practical knowledge, practice. Then you will get the job. Is this job or not? They are saying, no, this is not. It's not a job. Because a judge not be an employee. See, where is the tendency? They are saying that the judge are not an employee. So, there is no, this formula will work out. As I said, the engineering and the doctory. Doctory is also a job. No, as I said, it's a noble cause. Doctor is a noble cause. There is no employment, then it's noble to serve the sick. They are taking the oath that we will serve the sick people. Noble cause. But they are also putting about their money. But one law grads, after passing law grads or the LLM. What about LLM? You can say, okay, LLB not justified or not enough bookish knowledge. So one guy doing LLB, then LLM, so his age would be 27, and then after 3 years go to the practice. LLM will also go to the practice. LLB will go to, okay, LLM also go to the practice. After PhD will go to the practice. My son Honko LLB 10 years. Another elimination. And they will work under those advocates are passing 10 years back LLB. Might be forward the all bare acts. So they will work under that advocate who had already passed 10 years back and forgotten all the bare acts. And I have done my LLB and LLA, and then after I need to go for the practice. 3 years. Why should I? And this practice is any need to. I can purchase the practice certificate from any lawyer by paying the money. Is it or not? Is that reality or not? Yeah? So they don't know. They're sitting on the chair. They must know that if I pay the money, any advocate can give me that experience certificate, 3 years practicing. And any judge can be, because once I give it to, so the he will also accept. So by paying money, who will see I have practiced or not? And if I go to the practice, who will give me a client, boss? Shall I go get the clients? How I could get the practice? How I know the knowledge? Because seniors will not allow to the courtroom to enjoy. They will make me a peon or a law clerk. That is the reason you said that as a law clerk also. So you are making me a law clerk. So why you are sending me the colleges? Why you are sending me the university? Why you are asking me to the LLB, LLA, and then after come for the 3 year practicing is mandatory? Where is the relevance of your judgment, dear sir, honorable sir? Please explain. And how? I don't want to use that word dare to. How dare to? You are not believing on the book knowledge. You are asking on the practical knowledge. And why you are not included in the course? So why we are offering the course? 7 lakh, 8 lakh we are paying. Even 15 lakhs we are paying for the LLB course. We are paying or not? So we are paying the 15 lakh, 10 lakh and the 7 lakh, 8 lakh, whatever. And in that course you are not believe that we are mature enough to be a judge. You are asking and you are there to say book knowledge is not enough. You have to come from the practical knowledge. And how it will be proved that I have a practical knowledge? That by giving a certificate by the advocate 10 years. That means the opening of the window to earn the more money to them. They will say you will not practice. Even after practicing, they said you are not practicing. Is there any remedy? Do you have provided us? If I practice in 3 years, if any advocate denied to give us the certificate, then what would be my remedies? Is there any remedy? No, na. So if they deny and if they ask that you have to pay the 50,000, then only I will assign you as a certificate. Is this possible or not? Very much possible. And it would be. And this is the reality. Isn't? So it is the reality. You don't know. You knowing everything that I can purchase the certificate without getting the practical knowledge. I can also purchase the experience practical certificate by means of money. So you are opening up a window for a advocate. Those are 10 years practicing. They can value it 1 lakh to 50,000 because without this it can't be appear for the judges. Thirdly, why should I go in college and universities if you not believe on the books knowledge? So why you are not asked to the PCI, Bar Council of India, to design or frame the course in like way that it should be included that once I will pass out, I will be a mature enough as MBBS doctor. If after passing a MBBS can make the prescription, it is also threat to my life. But we have to consume that medicine and drugs, is it? So why you are not asking me asking to the BCI to adequate infrastructure to be made out? You are not asking to them, and even after, you are not taking into the consideration what about the LLM also. You are bracketing LLB and LLM in the same category. So who will go for the higher education in the law? So it is also a loss of the judiciary or not? It is the loss of the judiciary because you are not entertaining them to higher education. What are the means to go for the LLM? After LLB, if you are not allowing me, if you are sending to the anyone to get the purchase the certificate, and then why should I go for the LLM and you do not have the faith on the books? And what about the female? As the Honorable ex-CGI told us, female will wait after 23 and their 3 precious years. Their guardian will not marry them up. And how many middle class family after getting the father-in-laws or the after marriage, they can take the preparation for the judicial? And how they can arrange the judicial certificate experience, as you said, practical by the lawyer, if we are not to pay the 50,000? Where is the remedies? If any advocate say I don't know and I will not give you the experience, you will go. You can do anything against me. Is there any remedies? No. So what about this? Is there nothing? You not trust to the college, not trust to the universities, not trust to the even the degrees you are not framing and designing the course. And what about the middle class family children, the boys? If after passing graduate, any boys wait 3 years unemployed, if his aspiration to become a judge, then we must be prepared for the judge, or they will wait. After passing graduation, they will unemployed and 3 years course period and wait. And in a practice, as you said, go to the practice to the court. How much money they can earn? They do not have their family. They do not. I'm saying those honorable judge doesn't have their salary and this might be they have forgotten the reality of the hardcore in our Indian lower middle class family. What they are suffering. They are suffering for that. If I pass from the middle class, I pass graduation. 3 years I will be cross period and I will wait. Because in practice I can't earn much more. And I will wait for the judicial. I should go any other way, other means, any other exam, any other things, any other post I will help. So if this is, as it is Ognibil, you know now Ognibil? I send you the video, the Ognibil and Ogni Path scheme. 4 year army recruitment. What had happened? The interest from the lower middle class and the middle class and the meritorious has gone in. Those are now in no any other means to survive. They are only joining 4 years. Because after 4 years you will pick away. What will be my future? Who will marry me? I get the job, but for the 4 years, any girl will marry me or his parents will make the relationship with me. I get the job for 4 years. Then after I will be, might not be, totally in doubt. So that type of career anybody wants. So what had happened? The trend, the aspirants, talent, and the super talent from the middle class, lower middle class, those are appearing for this. Right now they are not in interest. Just because this. So another thing, the judiciary system, the talented will not be interested to get a LLB degree. So are you promoting the judiciary? Are you promoting the strong legacy? Or are you promoting the strong dynasty? Or are you promoting the judicial system to be strengthening? Because if you want to strengthening, then you should open up the more avenues to come and join this judiciary. But you are stopping, they're hearing. From a middle class, lower middle class, I go to the law college. If I don't have that much of capacity to arguing or shouting or court management, as advocate, but it is also possible, no? If you are not a good advocate, you can be a good judge. You all agree or not? Might be you are not a good advocate, but you are a good judge, isn't it? So if I do not have a good quality to be an advocate, but I have a good quality to be a judge, you are deprive me, discriminate me. Again, any from the poor family, they will join the law college. They will go to the LLB degree. They will see after this advocate and this totally, what is in Bengali term, jar nai kono goti se kore okaloti. Jar nai kono goti se kore okaloti. Already exist in the market, and then after you are pursuing that, there is a one golden opportunity that okaloti nahi koti, but from okaloti not, after LLB I be a judge. But there is a kiyabi re baba boro hoye na judge hobi, barrister hobi, na pilot hobi, na doctor hobi, na engineer hobi. এই চাকরি তো বাঙালি ঘরে ছেলেপুলে জিজ্ঞেস করে জন্মের পরে বাবা বড় হয়ে কি হবে? জজ হবে, ব্যারিস্টার হবে, ডাক্তার হবে। ব্যারিস্টার মানে তখনকার দিনে ব্যারিস্টারের ল ছিল, মানে জজশিপই ছিল, কিন্তু মানে মোটামুটি বাংলা ঘরে আমরা কি বলি, বাবা বড় হয়ে কি হবি? জজ হবি, ব্যারিস্টার হবি, বড় ডাক্তার হবি, না ইঞ্জিনিয়ার হবি? কেউ বলি বাবা বড় উকিল হবি, বলি না তো? আমরা কেউ জিজ্ঞেস করি বাবা বড় হয়ে উকিল হবি, বড় উকিল হবি, কেউ বলি ডাক্তার হবি, ইঞ্জিনিয়ার হবি, না পাইলট হবি, নইলে জজ হবি, জজ ব্যারিস্টার হবি। এটাই তো বাংলায় কথা। তুমি আমাদের তাহলে সেই you are depriving us from become a judge, because from the very poor family of the lower middle class, how I will sustain my family? Tell me the answer, Honorable Supreme Court and CGI. Please answer me. If I am from the lower middle class, if I doesn't want to be an advocate, I will not allow to serve the judiciary. You are not hammering on my fundamental rights. As 2002 judgment is there, why it is required, and you followed the last 20 years. So in this 20 years, are you saying those who have become a judge, they are all foolish? From 2002 to 2025, how many judges have get this opportunity? They are not eligible, or they are not good enough judge. What are you saying then? Is this any reasonable? Those are 2002 to 2025. Become a judge without having 3 years experience. They are not good enough judge. They are not good because they did not have entitled for this 3 years experience. Whereas 1993, 3 years, criticized by 2022. And again you are doing same mistake what it had did in 1993. And again might be in 2032 or 2042, we will see again the same verdict that we are missing the super talent, we are missing the super lawyer or judgment. That means law students, law grads, they are not interested to become a judge. Can be possible 2032 or 2042, again another verdict will come from the Supreme Court that will cut it, the verdict of the 2025, as it is 1993, cut it by 2002, and it is followed to up to 2025. Now again you are repeating the manufacture of 1993, so again it could be altered, but in due course the 20 years, the number of aspirants, the number of dreams, the millions of dreams, aspirants, and the youth, and the girls, mainly, and the youngs, will less gets the opportunity. So is this not a discrimination? Is this not an injustice? Are you prevailing the justice? Now tell me, you all are three advocates is here, now arguing me that if I made any mistakes in my argument, if I go to the Supreme Court in front of Honorable Judge and if I argued, now you as take the in behalf of the Supreme Court, make me wrong and where I have made a mistake. Tell me, if you are the Supreme Court judge or if you are in the sides of the Supreme Court judge, now tell me that in which and what side I made a wrong. Because 1993, 2022 and 2025, the same thing. My argument 3, education system, why not revamped, not restored or redesigned or retrained? Why you are not having the faith on the university's degrees? Why you are not framing what is the inadequacy you are feeling have to be looted code and all these things in due course? Why you are asking for the 3 years experience? Where is the validator I can buy and purchase from the AD lawyer by giving the money? So where is the authenticity what you are desiring? And how many days you will wait from the poor family children to become a judge after passing out the grades? Because after graduation, every family, their father at the age, we are the balancing of the family, the system, no? That once we will passing the graduate, our father gets retired, isn't it? This is very practically. So then they will retire their pension. So we have to suffer and we have to survive and we have to take the responsibility of the family. This is the mainly lower middle class and the middle class situation. So millions of the lawyers from the middle class and the lower middle class, after graduation, they will crossing the 3 years to become a judge. And how much money they will get from practice? They can support this high inflation, high price market. Can their earning can support, and their senior will allow to them. You don't know the senior, reality. So by taking this practice, can I feed up to my family? But if I am a good student, enough student, if I get the opportunity, one chance I will crack the judicial, I will say, take the salary, I will support the family. And the aspiration to be in the just after the graduation will be there. No? So this is my 3 orientations of the question to the Supreme Court. And the lots others, whatever I have discussed. So you tell me, where is the I am wrong? If I am not wrong, you don't feel. You write the letter to the CGI. You write the letter to the Solicitor General, Prime Minister, President and Vice President. And you are saying what would be? One after one, if the letter will charge would be there, no? They will think about. This is a concern of your dream. If it had happened with me, I will not tolerate. Because once I can see that 1993 judgment has deferred by the 2002 judgment. This is not the first judgment. And you have told in your judgment it is restored. Restored which one? 1993. Why you are not following the 2002 judgment? Because they have already criticized 1993. And you are again doing that 1993. And you are saying that after taking this practice 3 years, they will be good enough. If I am a law pass, a division, taking the practice to the, some advocate, get a certificate, I will go for the exam. But I am first class first topper. But my family very poor. I can't survive and sustain for this race. So if I out from that race and this third class, third division pass out student appear for the judicial, so if he gets the 58, where if I were, I will get the 84. But I am not there. Why? Because to serve my family, to take care of my family, to earn the money, I have left that field. Here what I am saying, I am first class pass, but I am from very poor family. If I appear that exam, I can score 85. But as I am from poor family, I left the field in the exam. One third class pass, but the rich family boy, and appearing that exam after 3 years of practicing and by purchasing that advocate certificate, and he scored 65 or 44 as the highest. So, who will be the best judge? That one or me? That poor child or that third class purchased certificate holder guy who scored 54? Whereas I can, if I get the opportunity, I can score the 84. You are getting in your system 54 as a judge.
But as you remember, you had given the example of P.R. Dohal, the Chief Justice of India. He also practiced law for. He was also practicing in civil matters and all. Then after, he became a judge. So, pass out student doesn't know the format of affidavit, the age, the knowledge, the prayer, then the
Yes, I accept. If it is your argument,
this is the
no. If it is your argument, I accept. No.
Then what is supposed to be required for any petition?
See, I am a MBBS doctor. No. Your
We can know this.
Now listen me. Now I am saying I am being a MBBS doctor, but I didn't know the pharmacology, and I will be allowed to prescribe.
See, we are all advocates, but
Why you are not judge?
It's a noble thing. It's a
Who
noble
will
thing.
become a judge?
Some previous class.
Who will become a judge? Who will become a judge? First answer.
An advocate who has been practicing, who knows.
Without practicing, judge can be made or not. Last 20 years we have received lot of judgment. So they are good enough or bad? They are good enough or bad?
If we know the procedure is most important thing, because without the procedure you can't just you can't compete in court, right? Without procedure.
So what should I learn in the moot court?
And we will
What should I learn in the moot court?
Moot court is nothing. Moot court, I am telling you.
You are saying nothing.
Moot court doesn't give you whole idea.
Why not?
It's a kind of debate only.
No.
No.
Why is it is why you are not making it framed as mandatory? That it should be as it is the environment and that situation it should be, and there will be a passing person to pay attention.
Become very costly and that will not.
Whatever government will pay for this. Government will pay for this. No, listen. For doctorate, if I'm putting a 2 crores rupees for a make a one doctor in a medical government medical colleges, and the professor see, listen. 50 lakhs of 1 course in a private colleges for a doctor. Okay, government colleges bearing that much money and making that infrastructure to make them.
They are becoming doctors.
Okay.
And we are also giving that amount, we are becoming advocate.
Yes.
But judge is something different.
No.
We have to classify that.
So from where you will get the knowledge?
We will get the knowledge from practice. That is the thing which I...
How?
Because
How?
until and unless we
Practice is different.
We can't know the
Practice
small
is
things,
different.
We can't know the procedure. We can't argue with the police. We can't go to a
From
police
where
station.
we will get these things
We
from?
can't...
Practice is listen. This is the thing. Practice comes out of the book.
No, it doesn't come out of the book. It comes with the book. What we are studying, it comes within it.
Then
It is coming from it.
what is practical?
The practical is something different. Practical.
What is practical?
Procedure.
Tell me.
Procedure.
What is the see the procedure also followed our books or not? Procedure. No. Let me don't say in a vague manner. Just clear me. Procedure. Listen. We are saying
It's a different kind of aspect.
books, what you taught, but it will be different in book.
Yes.
So that difference you make. You should eliminate that differentiation. For this, you can't discriminate me. So why you are not including in the course? This can't be. Oh, you are saying as it is going on, you have to adopt. You are saying no. Why we are not restored? Why we are not reorganized? Why we are saying that the college life and the college knowledge and the code is quite different.
Law is a huge thing. We can't do everything
Within 3 years it can be. Within 3 years it can be. Elizabeth, tell me. Within 3 years it can be. Let me the judge, let me. I'm just telling you within 3 years. Okay.
You also know which.
No. Judge also doesn't know anything.
Yes, sir.
Okay. So this is the thing. So they are not judge. They are not calling judge. They are not calling judge. Yes. How they are called judge? Oh my goodness. How they will be born as a judge? They will be born as a judge.
They were born as a judge. They will
how-
practice and become a judge.
No, they will clear a wrong. They will clear a judicial exam, then they become a judge. Yes. So in your judicial paper, what are being asked? Now, you will be judge bookish.
Out of the
See,
book,
court LLB degree bookish. See. Now, let me explain. Book, LLB degree. Judicial exam, LLB degree. Code to be followed, all the books and their acts. So out of these books and context, what the things you are practicing in the code, which you are not marginalized or adopted in the due course, if you think that is inadequate, which is you are saying practical, like a practical. So if it is so important practical, so why at the time of judicial exam, why are you not taking that practical paper? Why you are doing that?
Just give
Why
No,
that?
I'm giving you an example. Just give me
No, not examples.
What is the amount of code fee given in an assignment application? Not user. Please. Exactly the thing. That is the thing. They are incorporating.
No, listen. Any. No, listen. Stop. In any judge, need to know application fee.
Yes, obviously they
Why?
need to know everything. That's why.
In everything. That is why he is judge. If it is so, then why it is not pursued in your books? Why it is not pursued in your
It is there. There is a book for code fee, and we should study those.
So,
books. But in our code,
no.
there is no
You are claiming right now with that this is from practical knowledge. Is this? Or you are saying it is already. You are saying it is no. You are gaining that. No, but you are gaining this knowledge by practical because you are avoiding the books. You are saying everything in books, and now you are saying we are getting it practical.
We are practicing and we are referring through the books. We are referring through the books and we can't grasp everything
From the
in our institution. No, for that, we have to go for practical knowledge. We have to practice.
So a surgeon make his practice during his course or after passing his course. Now tell me, practical knowledge, subject, not books. Body is there, dying body, cutting, surgery, stitching, organ parts and everything. So for this dying body kept in the medical colleges. Okay. So after passing, if you require as per your version, practical is quite some different. Okay, I accept. You put it in your course.
you are not getting what?
I'm getting everything. You just tell me MBBS doctor. You are saying as you say.
Every doctors have their interns.
As you
And
say,
they get the knowledge from
okay.
from their
As you said, law is vast. Medical science is also vast. But once I get the MBBS, once I get the LLB, why should there be?
because
Why?
until and unless we practice, we can't get
Again,
the knowledge.
again, your word practice. So MBBS doctor without any practice can be prescribed.
Like that.
Sorry?
A doctor doesn't become. They will also go through the internship. They will also go through the process of internship.
What kind of?
They will first observe from
That is in college. It is in college course. Is in college course.
That doesn't.
It is in college course. If you are now,
Not college.
you are not.
College will never
You
be-
search any medical course. After getting an MBBS degree, there is no intern. Before every course to be completed, whatever the intern to be done.
And we also have our interns in our 5 years thing. We
As
also
I
have
am saying, I am
internship in our
agreeing.
5 years thing.
I am not disagreeing with
But
that thing.
still we
That
can't
practical knowledge, if you required, you ask to the damn colleges where you doesn't have the belief that the college has given the sufficiently or the enough knowledge to the grads. You make sure if I am offering you the LLB degree, you are a fully whole advocate. This is my words. After getting the degree, if you saying go for the practical, then you will say after getting the driving license, I can't drive even the car on the road. Tell me, can I or can I not? There is also threat of life nothing. Firstly, once I learned in a see now, listen, I am giving you the practical, you know also the practical. Now I am arguing. I'm enjoying, I'm arguing because I will argue with that. Every driving school giving you the driving license.
First they give learner right?
That is different. I'm asking you, they will give you the driving license at the end, and for this they will offer you 20 classes. Okay, Marilyn, in 20 classes in the road, how much you learn, and then at the time of the RTO, you are going for this driving license, the driving school, how it is managed, and how you get the driving license, all we know. And then after, once it is in my pocket, I can drive the car. I do not have any practical knowledge. And accident will be occur. The punishment will become to be okay. So the practical knowledge we do not have. Everybody knows, but I allow to drive. And for this, accident, loss of life, loss of property can be done. So why you are not asking me? That is your driving is okay. After completion your degree, and your degree means the driving license you own, you can't drive until and unless you will practice under someone another 2 years, 1 year, or half or 6 months, or even 15 days.
Consider this fact that a learner license has been given where 1 month time has been given
For what?
to practice. So
Is there enough?
thing is
Is
that
there enough?
We are getting
There
we are
enough?
getting
Any
advocate.
doctor,
We are certified as an
any
advocate.
driver.
That is different.
Why? How it is different?
We are certified as an advocate.
No.
That is different. But a class of judge is very much different from advocate.
How?
You are just mixing up the whole thing.
No.
You are mixing up the whole thing.
No.
A class of
I become a
He's a
judge.
judge.
Listen, no, judge. What is this?
he is giving
No. I am giving also. Oh my God. I will also prescribe to the patient. I will drive to the car on the road.
You are
This is
also
also-
giving consultant to your client also.
Sorry for what?
For being an advocate.
How I will become a judge, boss? How I will become a judge? Tell me the first root cause. How I will become a judge? What are the process?
process. They have given the process.
Then what?
Now,
LLB judicial exam. That's all. Okay. Okay. Judicial exam. LLB and judicial exam from 2002 to 2025 without having this experience or so-called practical knowledge, those are being a judge. They are delivering the honesty and good enough in their judgment. You accept it. So now what had happened that readily your experience and your practical knowledge is so important. And if it is so, how you will judge my practical knowledge in my judiciary exam, in which paper and which question and what question?
It's not about the judicial examination.
Oh,
It's about
I offered
on the chair.
how
It's about sitting on the chair.
how
That is the main thing.
no, that is not main thing. Nobody can sit on that chair until and unless he will clear the judicial exam and the interview. So once I clear the interview, once I clear the written exam, which is all depends on the books and from the books, and my eligibility is also dropped. You tell me now, who will? Who will? You tell me.
That's why there is a session of interview.
It's okay, fine.
That's why there is
So
a session
without
of
practicing, we have practicing.
So
Without having practice and practical knowledge, last 20 years, we are appearing that interview code and I passed and then I become a judge. এরকম জাজমেন্ট করতে থাকবে, ওকে কাউন্টার দিতে হবে। তুমি ভাবছো ও যদি ওর এগেনস্টে যে আসবে সে দেবে না, দিতে থাকবে, আমার জায়গা নড়াতে পারবো না, কারণ আর ফর্ম ও জোরে দিতে ছেড়ে দেবো। তাহলে এই 20 ইয়ার্স সব জাজমেন্ট গুলো মুছে দাও, আমার তাহলে 20 ইয়ার্স সব জাজমেন্ট মুছে দাও বস। না, সেটার জন্যই তো নয়, ওই 20 ইয়ার্স সব জাজমেন্ট আমাকে মুছে দিতে হবে যদি জাজমেন্ট গুলো ভুল হয়ে থাকে। ইন জাজেস where at the pin they are losing the whole cream from the system, because the honestly poor lower middle class and the girl child will not be in there. No, I'm not asking to be with me. You are side of the Supreme Court, okay? No, I am not asking. I am very much appreciating the Supreme Court verdict. Practical knowledge. You should induct into the court. You should input into the college. You should raise the tenure of the course. 3 or 5 or 10 years. I do not have a mind. I don't have. Yeah, LLB course required 5 years, 10 years. So after 7 years, just 3 years in the college, 2 years every day go to the court. 5-year LLB is there. So you ask, that's a 3 year or 2 year to be taught in college. And last 2 years, every day we have our infrastructure in the court. Government should be made that every student will go to the court and they will appear in the every bench and the courtroom. They will learn the practical.
But I do a matter. How will you learn?
You give me like you said a learner license.
That should be incorporated also.
You incorporate whatever you need. But after getting my LLB degree, why you have brought me to appear for the judicial? By this fake practice and practical, where without getting anything, I can arrange the certificate. Isn't it or not? Is there any relevance? Is there any authentication? My question is challenged to that one. If you need practical knowledge, I accept yes, practical knowledge. You induct the course, you increase the course, you divide the court practice session, or without having this 1 year or 2 year experience, you doesn't give me the LLB degree. Let us চুকে যায়। আমাদের বাবা পরিষ্কার করে দাও, আমার LLB 5 বছর দিব, যেমন আর্মি নেভি এয়ার ফোর্সে কি আর 3 বছর তোমায় পড়াবে, 1 বছর তোমায় নিয়ে গিয়ে বন্দুক চালানো শেখাবে। আর্মিতে তোকে যখন এই এনডিএ পাস করবে, মানে উচ্চ মাধ্যমিকের পরে, উচ্চ মাধ্যমিকের পরে নিয়ে কি বন্দুক চালাবি না, উচ্চ মাধ্যমিকের পরে গিয়ে 3 বছর গ্রাজুয়েশন হবে, 1 বছর নিয়ে গিয়ে বন্দুক আর মেশিনার এয়ারপোর্ট সব চালাবে। পাইলট প্রথমে তোকে কি করবে, থিওরি পড়াবে, পড়িয়ে প্র্যাকটিস করাবে, ছোট্ট প্লেন দেবে, ছোট্ট প্লেন নিয়ে চালাতে দেবে, তারপরে একটু বড় প্লেন দেবে, দিয়ে চালাতে দেবে, পাইলটকে চালিয়ে যখন ওকে ফাইনালি পাইলট দিয়ে দিল অফার, তখন পরের দিনও যদি যুদ্ধ লাগে ওকে কিন্তু মিগ 1 বা মিরাজ 1 বা সুখোই দিয়ে ছেড়ে দেবে। Am I right or wrong? তখন কি তুমি 8টা কমপ্লিশন, তুমি বলবে আবার প্র্যাকটিক্যাল করো, তারপরে তোমাকে যুদ্ধ বিমানে যুদ্ধ করতে যাবে, যা করার তুমি আগে করো না বল। কিন্তু তুমি আমাকে জব এমপ্লয়াবিলিটি থেকে কেন বঞ্চিত করবে বস? আমার কাছে কথা হচ্ছে, যদি আমি একটা এয়ারফোর্স অফিসারকে বলি তোমার কলেজ হলো, পড়া হলো, প্র্যাকটিস হলো, সব কিছু হলো, তুমি জব পেয়ে গেলে, চাকরি পেলে, এরপর তোমাকে এক্সপিরিয়েন্স বা তোমার সব হলো, এবার তুমি 3 বছর মতো এক্সপিরিয়েন্স করবে। এক্সপিরিয়েন্সের নামে না 3 বছর মতো পোস্টটাকে 3 বছর পাঠিয়ে দাও, কোটা ইনফ্রাস্ট্রাকচার করো, স্টুডেন্টকে পাঠিয়ে দাও, ওখানে গিয়ে বলো যে শেখো, যা যা শেখাবার তুমি শেখাও। এলএলবি ডিগ্রি দেওয়ার পর জুডিশিয়াল দিতে বলো। 2002 থেকে 2025 পর্যন্ত জিএসটি যখন এতগুলো জাত যখন সুযোগ পেয়েছে, আমি হঠাৎ কেন বঞ্চিত হতে যাবো? একবার বলো তো আমাকে। না, ক্ষোভ প্রবের কথা নয়, আমার কাছে ক্ষোভের কোনো জায়গা নেই, আমার কাছে লজিক আছে, আমি লজিক দাঁড় করিয়ে দিয়েছি। 1993 কাটেড বাই 2002, 2002 কাটেড বাই 2025, রিপিটেড বাই 193। আর কি যা কিসের ভিত্তিতে, যে ভিত্তিগুলো সবকটাই ইররিলেভেন্ট। আমি সার্টিফিকেট যে কোনো টাইমে জোগাড় করতে পারি, আমি একদিন কোর্টে না গিয়েও জোগাড় করতে পারি, আমি কোনোদিন প্র্যাকটিস না করেও পয়সা দিয়ে যা কিনতে পারি, আমি না বলেও কিনতে পারি। উল্টে ওদের ব্যবসা বাড়িয়ে দিয়েছো, 50,000 1 লাখ টাকা চার্জ করবে, আর আমি ওখানে প্র্যাকটিক্যাল নলেজ শিখেছি, তারই বা কি প্রমাণ আছে? সেই তো তুমি জুডিশিয়ালে আমাকে 25 নলেজকে নিয়ে প্রশ্ন করি। তাহলে তুমি আমাকে বলো আমাদের জাজমেন্টের জায়গাটা বলো, বলো। হ্যালো, আর কথা বলুন স্যার। ওই আমাদের জুডিশিয়াল বিরাট ভার্ডিক্ট এসছে, ওই নিয়ে আমাদের ক্লাস হচ্ছে। 7টা তো ঠিক আছে, ঠিক আছে। আচ্ছা, তাহলে হ্যালো, হ্যাঁ এটা আমার নতুন ফোন, কেন পুরোনো ফোন থেকে ফোন তুলে দিলাম। আচ্ছা ঠিক আছে, তুই পাঙ্গি যাই হোক। আচ্ছা শেষ করি। আচ্ছা কি বলছিলাম, তোর ক বছর? তোর
2025।
চাপ নেই, তোর কবে? 20। তোর তো চাপ নেই, চুপচাপ না, যা সার্টিফিকেটটা জোগাড় করে দেখ। তুই কবে বেরোচ্ছিস? ওগুলো কিচ্ছু ডিসকাস, ওগুলো হাইকোর্ট থেকে এখন কোনোটাই বেরোয়নি। ওগুলো সরকার বলেছিল আমরা নোটিশ জারি করবো, যদি নোটিশটা বেরিয়ে যেত তাহলে এই 3 বছরের সার্টিফিকেট লাগতো, কিন্তু নোটিশ জারি হয় বেরোবে বলেছিল। নোটিশ যদি ডিসক্লোজ হতো 23-24, তাহলে এই সব লবচন্দ্র লাগতো না। নতুন নোটিশ বার করবে, ওই জন্য ঝুলিয়ে রেখেছিল, যেভাবে গুজরাট ঝুলিয়ে রেখেছিল, বাকি সবাই ঝুলিয়ে রেখেছিল, বার করবে ওইটা। এটার জন্য ছিল, আরেকটাও আছে এখন, সেটার জন্য কি হয়েছে সব নিয়ে ঝুলছে। তো যে চাপ নেই, কিন্তু ঘটনাটা হচ্ছে যে এটা ঠিক না, ঠিক হলো না। আগের থেকে বললেও, আগেরও বলা নয়, কারোরও বলা নয়, জিনিসটাই পেরে কাজের কাজে আসবে। এটাকে শুধুমাত্র ওই যেটা বললাম, মেয়েদের সিস্টেম থেকে হাঁটানো হলো, গরিব মানুষগুলোকে সিস্টেম থেকে হাঁটানো হলো, নিম্ন মধ্যবিত্তকে সিস্টেম থেকে হাঁটানো হলো। ও এখনো গ্রাজুয়েশন পাস করেছে, করে এখনো ও ধরে রেখেছে, ওর সঙ্গে বাকি বন্ধুরা ধরে রেখেছে। ম্যাক্সিমাম যারা লয়ার তারা তো খুব জেলাসি, তারা শুনে হাত তালে নিচ্ছে, কবল বাজাচ্ছে রীতিমতন। আমি পোস্ট করতে বলছে, বেশ করেছে সুপ্রিম কোর্ট, আপনি কনস্টিটিউশন করুন, আমি আমাকে পড়াতে আসছি। মানে ওরা ভাবলে যে আমি লিখেছি যে তো মানে আমি আমার সব অ্যাডভোকেট কমেন্ট নেমে গেছে, ঠিক করেছে, ঠিক করেছে, সুপ্রিম কোর্ট ঠিক করেছে, বেশ করেছে, ভালো করেছে, ভালো করেছে, হ্যাঁ যান কনস্টিটিউশন করে দেবো। আমার 233-এর 2 পড়াচ্ছে। ওদের জ্বালাটা কি? আমাদের বয়স হয়ে গেছে, জাজ হতে পারেনি, বা আমাদের মুরব্বী জাজ হবে না, আমরা হতে পারবো না, আমরা আরে তার মানে ওই এলেনটাই নেই, ওই লেভেলটাই নেই। আমি ওই লেভেলে যেতে পারবো না, তুই বলে যাচ্ছিস কেন? ওদের বেশ করছে, এই তো সব লক করে দিচ্ছে। যদি মনে কর কলেজ থেকে বেরিয়ে কেউ যাচ্ছে ব্যাটিং করতে, ঝাঁক করতে, আর ও যদি বেরিয়ে চলে এসছে বা ও যদি জাজ হয়ে গেছে, ওটা গায়ে তো ঝাল লাগবে। ওদের ব্যাটা লক করে দিয়েছে, হ্যাঁ শব্দ দিয়ে 3 বছর 3 লাখ, খুব জাজ হতে গেছে। প্রীতি সেট এক্সপ্লয়েটিভ ক্রাইম, হ্যাঁ লক। সব ওদের কলেজে সবাই আনন্দে আছে যে এদের এখন 3 বছর গ্যাজেটে দিয়ে দেবে। ওরা যদি আজকে ভাব, যদি 3 বছর আগে আসতিস, এতদিনে জাজ হয়ে যেতিস, যদি এই সিস্টেমের মধ্যে থাকতিস, 2022-এ পরীক্ষা দিয়ে বেরিয়ে যেতিস। তুই 2020 বললি তো, কিন্তু তুই 2022-এর পরীক্ষা লাস্ট পরীক্ষা দিয়ে বেরিয়ে যেতিস, জাজ হয়ে যেতিস। তোর এই প্র্যাকটিক্যাল আর জাজের মধ্যে কি বিরাট তফাৎ অন্তত তুই বুঝিস। সেটা যদি 2 বছর তুই করে নিতিস, তুই হয়ে গেলে বাকিটা কথা তো জেলাস তুই। যদি 3 বছর রোগড়ে তারপর হবি, হ্যাঁ ঠিক আছে, রগড়া, সবাই রগড়া, রোগড়ে আসো, ঠিক আছে। চিঠিগুলো পাঠা, আমাদের তরফ থেকেও ওটা হিয়ারিং করা হবে, ছেড়ে দেওয়া হবে না, সবাই মিলে ঝাঁপিয়ে পড়া হচ্ছে। কিছু ব্যাপার পলিটিক্যাল রয়েছে এর মধ্যে, বুঝতেই পারছিস। এদিকে হলো রাষ্ট্রপতি চেঁচায়, ওদিকে হলো উপরাষ্ট্রপতিও চেঁচায়, এদিকে হলো মুখ্যমন্ত্রী চেঁচায়। তার কারণ হচ্ছে সব মানে পুরো ব্যাপারটাই এখন পুরো একটা আলাদা এতে চলছে, হ্যাঁ ছন্দে, আলাদা ছন্দে চলছে। অতএব এই ছন্দেরও মানে আমরা বুঝি, কিন্তু মুখ দিয়ে ফসকে গেছে, এখন আবার মুখ দিয়ে না বলানো পর্যন্ত তো কিছু করতে পারবে না। এখন এখন এটাকে দিয়ে যদি আটকে দেওয়া যায়, একটা চেষ্টা করছি যে যদি দিলে এটাকে অন্তত সাস্টেন করা যায় যে আন্ডার রিভিউ, অতএব 2002 অ্যাপ্লিকেবল, এটা করার চেষ্টা করছি। তোরা চিঠি চাপাটি কর, বাকিটা দেখছি। আসলে তোদের ল সেকশনের ছেলেপুলেরা বড্ড ঝুলিয়ে, মানে আদৌ কোনো সেই নেই। তখন অগ্নিবীর অগ্নিপথ হলো, তখন মানে হই হয়ে গেল, দেশভর আগুন চলে গেল, চারিদিকে মানে চার ভাঙচুর, আমাদের এখানে রাশ, যেটা হিউজ ব্লাস্ট করে। যেমন অ্যাডভোকেটদের বলেছিল পরীক্ষা দেবে, নাড়িয়ে দিয়েছে ধূপধুড়ি, তখন ধূপধুড়ি নাড়িয়ে দিয়েছে, ও কটা আমরা কেউ পরীক্ষা দেবো না, যা শিখে গেছে বেশ গেছে, আর কোনো পরীক্ষা দেবো না। তোদের ইউনিটি নেই না, কিন্তু জাজেদের যে অ্যাডভোকেটদের যে বলেছিল যে তোমাদের আবার পরীক্ষা দিতে হবে মাঝে মাঝে, 6 মাসে 1 বছরে দিয়ে আবার হে হিরো ভুলে মেরে দিয়েছি, চোখা মেরে চালি, আমার পরীক্ষা, তুই বাবা, ও সব হই সব বন এরকম যদি এখন হতো যে সব কোটে, এটা তো জাজিমেন্ট, কিন্তু বাকি জাজিরা যদি বলতো যে আমরা সব বন্ধ করে দিলাম জাজিমেন্ট, তাহলে একটু পাল্টা হতো জাজিদের। কিন্তু সবাই শিখে নিচ্ছে, কারণ এই শিখে তো আমাদের ঘরের ছেলেগুলো সব ঠিক খাবে, আর যারা বলবে তোরা গরিব মানুষগুলো বলবে, আর মেয়েরা বলবে, আর নিচের তলা আছে, বুঝতে পেরেছিস তো? এই জন্য কারণ নেই, এটা ব্যাপারটা পুরো সেটিং, মানে ওপর লেভেল আমাদের থাকবে, ওখানে যেন কেউ না ঢুকে পড়ে, আমাদের সোসাইটিতে যেন বেরোবে ওরা ঢুকে হচ্ছে না, বুঝতে পেরেছিস? আমরা ডিপ্রেসড হবার কিছু নেই, একটু হ্যামার হবে, কিন্তু পড়াশোনাটা কর, এবিপি ফেবিপি গুলো তো আছে দেখছি, আর এটাকে এখন মুখ ফসকে দিয়েছে। আমি কি বলবো এক্ষুনি তো তোকে আমি বলতে পারবো না যে না, অন্য কিছু হলে মমতা বন্দ্যোপাধ্যায়ের উপর আমার পূর্ণ আস্থা ভরসা বিশ্বাস ছিল, যে ওটা বলবে মানবো না, এই যেমন মানছে না, কিন্তু মানছে, মাইনে দিয়ে যাও, আর চাকরি ঠিক করে কম্পেনসেশন দিয়ে যাও, গ্রুপ বি গ্রুপ সি বাড়িতে বসে তেরে মাইনে পাচ্ছে, টিচারদের চাকরি নেই তেরে মাইনে পাচ্ছে, মাইনে দিচ্ছি আবার চালাচ্ছি না, মাইনে তো আরো বন্ধ করি, টাকা দিয়ে গেছি, তোদেরও বলতো আমি তোদের পরীক্ষা নেবো, আমি প্রথমে নেবো, কারণ ওই লেভেলে থাকলে ভরসা ছিল, ও বলে দিত এখন হয়তো ও ঠিক পাগলা তুলে দিয়ে বলতে এখন অলরেডি ডিজিটাল হয়নি, হলে ও বলেছে করতে, করবো তার মানে আছে, কি হবে তার মানে আছে, আমি এই কারণে করবো। আমার ওইটা মমতা বন্দ্যোপাধ্যায়ের উপর ভরসা আছে, কিন্তু এই ক্ষেত্রে মমতা বন্দ্যোপাধ্যায় করবে না, কারণ কোনো পলিটিক্যাল এজেন্ডা নেই, ইস্যু নেই, কোনো চেঁচামেচি নেই। হ্যাঁ, যদি এরকম মানে ল স্টুডেন্টসরা চেঁচাতো ব্যাপারটা নিয়ে হয়ে যেত, তাহলে হয়তো হ্যাঁ হচ্ছে, ও কোনো না, ঠিক আছে হচ্ছে, হবে না, আমার পরীক্ষা তো হয়ে নেবে, আমি হয়ে নেবে, নোটিশ হয়ে যায় করবে, একাডেমিক ক্যাম্পেটা হাইকোর্টের সাথে কাছে হবে, ক্যাম্পেটা হাইকোর্ট হয়তো বলবে না করতে হবে, অন্য করবো না, হরিচই করবে, সেটা আমি বলতে জানি না, যদি সেটা মনে করবো আমি আরো বৃহৎ কিন্তু মারবো, প্রশংসা করবো, কারণ সেটা পরে একটু দেখা যাচ্ছে, দেখে নিই না, চিঠিগুলো কর, চিঠিগুলো পাঠায়, তারপরে চিঠিগুলো অ্যাটাচ করে সব পাঠিয়ে দেন, তারপরে আমি দেখছি, বুঝতে পেরেছিস? যেখানে বললাম চিঠিটা পাঠাও, ভাস্বতীকেও বললাম, ভাস্বতীও রিকোয়েস্ট হয়ে গেছে, এও রিকোয়েস্ট হয়ে গেছে, সবাই অনেকেই আছে যারা ফার্স্ট ইয়ার দেওয়ার ছিল, একটা ডিপ্রেশন, আমরাও রিকোয়েস্ট, সব থেকে বড় কথা ট্যালেন্ট বেরিয়ে যাবে, এটা শিওর, গরমে না হলে। আর ওই কোর্টে গেলে দেখছিস ওকে তা গেজিয়ে গেছে, গেজিয়ে যাবে, না আমি তো দেখ আমার আমার আর্গুমেন্ট আমি রেডি করেছি কিন্তু উইদিন 5 আওয়ার্স নয়, আর্গুমেন্ট এসছে 11টা, ওদের ক্লাস নিয়েছি 4টে, তার মধ্যে সব কিছু করে আমি আমার আর্গুমেন্ট রেডি করে দিয়েছি, ঠিক আছে, এটা পাঠিয়ে দেবো। সুপ্রিম কোর্টের 1993, 25 সব ঘেটে কোথাও পাবি না, সবাই হয়েছে হবে কি হবে বটে, কোথা থেকে হলো কেন হলো কি হলো কি হলো আর্গুমেন্ট কেউ করে, এখন ভয় পাইছ, আমি ভয় পাই কি ভয় পাবো নাকি সুপ্রিম কোর্টে, সুপ্রিম কোর্টের জায়গায় তো প্রশ্ন পাবো আর ঝগড়া করা আর্গু করা লজিকের ভাই আমি তো সব তুলে দিয়েছি তো তো দেখালাম 15 পিস আছে কোনো ভুল বলেছি। আমার প্রশ্ন হচ্ছে 93, 2002 শেষকালে বললো ওই 20 বছরটা ছাড়ুন না স্যার, ওই 2003 স্যার প্রত্যেকটা স্যার ওইখানে যে একটা লাইনে জাজমেন্ট এদিক ওদিক হবে, একটা লাইনে, সেখানে আমি পুরো 2020 প্যারা তুলে রান করিয়ে দিয়েছি। আমি একটু টিভিতে বকবক করে নিই, মন খারাপ করেছে আছি লর্ড জীবিকা থাক কন্টিনিউশন থাক এদের কিন্তু খুব আনন্দ হচ্ছে, ভাবছে ফার্স্ট ইয়ারের ছেলে মেয়েগুলো সব সাইডে যাবে, আমরা 3 বছরে থাকবো, মানে কত 3 বছরের মাল আমরা আওয়াজ করে যাচ্ছিস, এদের কি আনন্দ, যত বড় শব্দতেই বিশ্বাস করবি না।
স্যার অনলাইনে লোপামুদ্রা আছে, তিয়াস আছে, দেখে নেবেন।
আচ্ছা স্যার, হরি স্যার, হরি স্যার, হরি স্যার,
ইয়েস স্যার।
আমার ওই হেডফোনটা পাঠিয়ে দাও না আর একটু জল পাঠিয়ে দাও না।
অনলাইনে তিয়াস আর আছে,
হ্যাঁ রেকর্ডিংটা কেটে দাও,
লোপামুদ্রা আছে।
মানে বেরিয়ে যেতে বলো তুমি এটা